what's up? What's up? What's up? It's your girl Neek, and you're tuned in to Neek at Night. And over here, we are the what? We're the Night Owls, okay? And the Night Owls shop on my website that you see right here, neekatnight.com. But anyways, so today we're going to be talking about Tory Lanez as it pertains to the incident with Meg Thee Stallion, where she accused him of pow-powing her in both of her feet. Now, he took this situation to trial. From my knowledge, I believe he was offered a plea deal. I think that's kind of what the word on the curb was, that he was offered a plea deal that he rejected and decided he wanted to take his chances and take this situation to trial. Now, when this situation was took to trial, the prosecution laid out a pretty clear and concise diagram that they felt like pinned Tory Lanez as the shooter. Now, there was 3 people who got tested for GSR and 3 people that could be the potential person to be the shooter of this crime. Now, in the diagram, the prosecution basically put what notch does each one apply to and who is the most probable or who is the most commonsensical person to be the one to commit this crime. So they put out this diagram that you see forth here, and this was illustrated by, I believe, Nancy Dillon from Rolling Stone, and it listed each person that could potentially be the one who did this to Meg Thee Stallion. They listed Jaquan, Kelsey, and the defendant Tory. Now, she laid out all the things from each party, and it turned out that Tory Lanez is the one who unanimously checked all of the boxes as it pertained to who was responsible for this situation. So there was 3 people who got tested for gunshot residue. Out of the 3 people who got tested for gunshot residue, Kelsey and Tory Lanez both tested positive for GSR. They factored in the fact that Sean Kelly visibly said that he seen the muzzle flash go off near the girl, but when he visibly seen somebody shooting, he named Tory Lanez as the person that he saw shooting, and, you know, that was that. As it came to DNA evidence, it was inconclusive, so that could not be pinned on anybody. The gun was determined to be Tory's from what they recalled. Also, Meg Thee Stallion pinned him as the shooter. Also, Kelsey, in her September 80-minute testimony to the prosecution, she pinned him as the shooter. There was also a text message sent 5 minutes after the shooting happened, like right when in the thick of things, right when it happened. Kelsey sent a text to, I believe it was Meg Thee Stallion's bodyguard, that said, "Help, Tory shot Meg." Okay? And the prosecution felt like, okay, well, unless she's this criminal mastermind and she's already plotting her way out of this, I highly doubt that she's trying to cover her tracks that soon, et cetera, et cetera. And they felt like they took that as truth. Also, what was taken into consideration was the apology text that he sent to Meg Thee Stallion apologizing for this whole incident. Now, the final thing that basically nailed everything in the coffin was the jail text, the jail phone call, which seemed like he was, even though he didn't outright say, "Hey, I shot Meg, I'm sorry," they felt like it was pretty incriminating, and considering all of the boxes that he checked and everything that went against him, he was pinned as the person responsible for what happened to Meg Thee Stallion, and he was found guilty. Now, Tory Lanez was not happy with the outcome. He felt like it was not going to go that way. I think a lot of people were, and I'm not saying Tory specifically, but I think majority of the chatter around court, a lot of people thought that it was going to be a hung jury. And I think that a part of the prosecution going forward, they felt like they had it in the bag. And they did not exhaust all of their resources that they could have. Now, right before trial happened, Quan, he was, I guess, slated to testify. And when he came to court, I think he came to court, it was like a Thursday or a Friday. I'm going off memory. And he showed up ready to testify. And the prosecution said, hey, we're not going to put him on the stand as a witness today. If you guys want to put him on the stand, we're going to have to wait till after Christmas, and then we will have time to prepare what we want to ask him and things like that. But we're not putting him on the stand today. Tory's defense team decided not to use Quan, and they did not call him as a witness, and they decided to just get everything over with. Now, where they went wrong, I believe, is because right before Christmas break, everybody was ready to be over it. They wanted to spend time with their families. This is my assumption, my assertion of what I felt like the mood was. There was a lot of people who wanted to get this over with because the holidays were approaching. Many people have holiday plans. And I feel like, being that this happened right before Christmas, I don't know if his team felt like, okay, well, they want to get out of here, so maybe they'll just hang it or whatever. But they kind of did not exhaust all of their resources as far as allowing time for Quan to be prepped to get put on the stage, because he is the only other party who can give a clear account of what happened. Kelsey was there at the time of it. Megan was there at the time of it. Kelsey and Megan said their side. The only other person who would be able to lay this all out, who was not drinking, was not under the influence, he was sitting outside in his car the whole time while they was turning up. The only person who can give a clear account was Quan, and he was not put on the stand. So they end up not going with him. Jury went into deliberation. They found Tory Lanez guilty of all charges, and he was set to later be sentenced. Now, his original sentencing date was, I think, sometime in the later part of January. And within the time of that, he retained a new attorney, which I believe was David Kenner. And he retained this new attorney, and the new attorney was trying to wait, hold up. We're not trying to sentence him just yet. Let's put the paperwork together so that we can, try to get a new trial before y'all even conclude this one. There was a lot of delays because I believe David Kenner wanted to get the transcripts. He wanted to be able to see if there was any errors. And there was some type of issues with expediting things, in a timely fashion. So things kind of got continued. Within things getting continued, David Kenner, who was this prominent attorney back in the day, and he represented, I want to say, Snoop Dogg and his big cases, and Suge and some of his big cases. Something happened to where I guess he has some other stuff going on where he had to do. And then they brought on Berhoma and Jose Baez. Now, Jose Baez and Matthew Berhoma came on the case to finish out the retrial litigation, and they pretty much felt like they had this situation in the bag. They were going to social media, basically calling out the injustices of Tory. Tory Lanez was also having jailhouse calls, rallying his supporters and telling them that he was unfairly targeted, that he was, an innocent black man who was held down by the system, and he was wrongfully convicted. And it was all under the advisement of, I'm going to assume, his new counsel. Now, I'm going to share with you guys some of the videos that Tory Lanez shared to his social media accounts, and then we're going to segue into, once we get into this retrial and what happened in court. But before we go into court, we got to go what happened outside of court so we can give you guys a full rounded picture. Okay? So Tory Lanez decided to, finally speak out, and he made this message to kind of call out his stance of what he says was an innocent black man being wrongfully convicted of a crime. Okay? So let me pull this up for you, and then we're going to go forward after that. Okay.
Gascon, I write this message with the utmost humility, love, and respect for the remarkable.
All right, so his first message was to Gascon. So I believe Gascon, hold on, let me go to it. Gascon is the LA County District Attorney, and he is, I guess, like the main one or something. So his name is George Gascon, and Tory Lanez wanted to send a message to him saying that he was basically unfairly, treated as this black man or whatever. And he wanted to call on Gascon to kind of step in against the prejudices against him. So let's play this, and then we're going to go forward.
Steps that you've taken in regards to fighting for the justice of black and brown minorities. Today I take a stance as an innocent black man wrongfully convicted of a crime I did not commit. I've watched two district attorneys from your office by the names of Kathy Tarr and Alex Bott unlawfully misuse their authority to hide and suppress any and all exculpatory evidence that exonerates me and furthers my innocence. I was completely robbed and deprived of a fair trial. So on May 8th, my lawyers will be arguing a motion for a new trial. Not only do I owe it to myself to fight for my freedom, but I owe it to my 6-year-old child, my family, my fans, and most importantly, the hundreds and thousands of black and Hispanic minorities that cannot adequately fight for themselves. For 3 years, the prosecution has manipulated a false narrative that has left me with no choice but to expose the practices, the behind-door deals, and the unjust system that was used to illegally convict me and countless other minorities. We elected you because of your outstanding eminence in making fair and correct judgments in the justice for people of color. So, Mr. Gascon, I come to you today as a wrongfully convicted black man, not asking for sympathy nor compassion, but for you to simply do what is fair and right in the laws of California, and most importantly, in the eyes of God. Dear George Gascon.
All right. So that was his first message that he posted to social media, and he said, everyone please let @Gascon for LADA know that I deserve my freedom and a fair trial. If this injustice can happen to me, it's happening to so many more minorities that don't have the finances or voice to speak up. Now, after he sent that message to Gascon, he showed a written message as well. So I believe he showed his phone call message, and I think he wrote the message in written form as well, the same thing that he said in the phone call. So then at another time, he also did another call, and this is what he had to say.
I've been incarcerated for almost half a year over a gun that the DAs lied and said I shot. In 2021, they demanded I take a DNA test. I took that test with no pushback, delay, or question. Not only because I knew I never shot the gun, but mainly because I was 100% positive I never even touched this gun. In my trial, the verdict of guilty or innocent depended heavily on my DNA results. With the help of LA Crime Lab's DNA expert Randy Zepeda, DA Kathy Tarr and Alex Bott completely manipulated my DNA results and lied to the world, the media, and most importantly, my jury, by stating my DNA on the gun was inconclusive. That was an absolute lie. They went on further to say, inconclusive means that he cannot be excluded from the gun. My new attorney, Jose Baez, hired one of the best DNA experts in the nation to carefully analyze the same DNA test the fair and correct way. The results came back exactly as I knew this whole time. My DNA is 100% excluded and 100% eliminated from the gun. In other words, it's physically and scientifically impossible for me to ever have touched or shot this gun. After the correct and careful analyzation of my DNA testing, not only did our expert find my DNA 100% excluded and non-existent on the gun, but what's worse was the invalid and illegal tactics the prosecution chose to attain the results used to convict me. Based on the fundamentals of my DNA test, the only possible way for the LA Crime Lab to come up with an inconclusive result would literally be to stop the testing before it finished or completed its final result, which would have and should have shown completely my full exclusion on the weapon. In other words, District Attorneys Kathy Tarr and Alex Bott lied to my jury with false, incorrect, and incomplete DNA results, violating my due process.
Okay, I don't know if it's repeating or not, but you guys get the gist of it. So he basically, before he got his day in court to retry this, to ask for a retrial, he called out the prosecutors. He said that they manipulated evidence. He said that they basically lied and tried to say his DNA was inconclusive and things like that. But it turns out that when it was actually litigated in court, the prosecution had their own expert. Tory Lanez also had his own expert, and both Tory Lanez's original expert and the prosecution's expert agreed that the DNA was inconclusive and it could not include or exclude Tory Lanez. So we'll get into more of that in detail a little bit later, but I just kind of wanted to lay the foundation of what happened as we segue into this, because there was some things that were said kind of to twist things a certain way. And it's I was sitting in court. It kind of didn't really go like that, but hey, it is what it is. People got to paint the picture how they got to paint the picture. Okay, period. So let's move right on ahead. So Tory Lanez kind of campaign leading up to going in and having his attorneys do his thing. So they was riling up social media. A lot of his, Tory Lanez supporters was on go. They started to, feel like they had to go against anybody who they felt like wronged Tory. And, it just kind of riled up people and amplified people. And it just kind of, I don't know if that's kind of what made the judge feel some type of way, because up until they started releasing those things on the internet, the judge had kind of been working with them. He wasn't I didn't really see him really short with them and not really having it for them. But when it came to the day that they were going to retry this case, the judge was fed up with the defense, and he was very short with them, and he was not playing with them, and he was very much like this the whole time. So as they were giving their motions, this is very much what the judge was giving. Literally, he was on the stand and he was looking at them like this. No, we're gonna do it this way. No. So by the time we get there, it's the whole mood and the temperature of the court completely changed. But before we get into that, we're going to, I'm going to walk you through my day. So I arrived to court on May 8th, and child, I am trying to hurry up and get to court because I live outside of LA. So my homeboy, he was going with me to court, and as he was going to be there, make it there before me, he's reporting back to me about okay, this person, telling me the ambiance of what's going on in the hallway. And I'm like, dang, it's filling up. Let me hurry up and get there. I'm trying to get there. Boom. By the time I get there, most of the people already were there. So once I get there, our mom was there, Milagro was there from my radio, cousin Tino, who is always there. There was a lot of people who had been following this trial was there, ready to go and listen to what was, about to happen going forward. Now, as I came in, I immediately noticed, Mob Radio and Armand, and we had all squashed whatever drama was going on. And when I seen them, I immediately noticed that they was dressed alike. And I'm like, oop, not the twins. Because they both had on these powder blue suits. So I went up to them and I was just kind of talking and chatting oh, hey, what's up? How y'all doing or whatever like that. And as I was talking to them, they had, I guess the whoever had sent in a freaking bailiff and like pointed both of them out and basically told them that, you know, they were not going to be able to go in. They have been like excluded in this whole thing like that. They tried to get down to the bottom of it because they were under the impression that they can still go in as public, just not with their media badges. And that was kind of like this whole ruckus outside of the courtroom. There was people that was making up lies about like me having involvement. I had no involvement in that, none whatsoever. Don't got nothing to do with me. There was also people making up lies saying that I got kicked out of court. I did not get kicked out of court. I don't know where y'all got that from. People just be lying, and I don't know what y'all get out of making blatant lies. It's enough content with the truth for y'all to be making up lies. It's crazy. But anyways, moving forward. So after all of that kind of died down, then we go into the courtroom. The family, I can tell they kind of like were like apprehensive. When Tory Lanez first came out, he seemed like he was kind of like optimistic about like what could be happening ahead. But immediately the mood, like not even 20 minutes into us being in there, from like optimism of basically like what can happen? Is there a chance that he's going to be granted a retrial? Like he has these big heavy hitters. They have these witnesses that flew in. They have all of these strategies that they're going to argue. Like everybody, I guess, was kind of like, what way can it go? Can it go this way? Can it go that way? Immediately when stuff got kicked off, the judge basically told them, we gonna run it like this, and that's how we gonna go. The defense, which is Jose Baez and Matthew Berhoma, they did not want to go the way that the judge wanted to go. So basically what happened was they submitted a document for a retrial, right? And they listed 7 issues that they had that they felt was in violation of Tory Lanez's rights. They listed them 1 through 7 in their moving papers. And they said, hey, this is the issues that we have. 1, boom. 2, boom. 3, boom. Boom. Like, this is the issues that we have. This is the issues that we're going to bring forward. And this is what we want to talk about. So when they got into court, they wanted to go out of order of those issues. And they wanted to basically, like just run the show and put on, you know, their show as they see fit. They wanted to put on these experts. They wanted to get this person who's claiming that they made Tory Lanez post on the stand, and they wanted to get the lyric creative expression expert on there, and they wanted to get the DNA expert to tell his side. And the judge said, no, I'm not doing that. We are here to go over the errors of the first trial. We are not here to put on coulda, woulda, shouldas that you feel like coulda, woulda, shoulda happened at the first trial that they failed to put on. We're talking about the scope of what you guys said was the errors in the original trial, and we're going off of that. We're not going off of, well, we should have been able to say, have this creative expert talk, or we could have had. No, we're not going off of coulda, woulda, shouldas. We're going off of what happened and what y'all got a problem with. And we're starting with problem number 1. So Jose Baez and Matthew Berhoma, they like argued back and forth with the judge, back and forth with him about how they wanted to go in the order that they wanted to go. And one of the words that Jose Baez kept using was, we want to be able to persuade you the best way possible. And I kept thinking like, why do you keep like, I guess the verbiage that he was using, I don't know, it wasn't sitting with me. It's like, I mean, I guess that you are trying to persuade him, but I don't know, the way that he kept saying it was like, well, we got to spin it this way for you to kind of, you know, but it's like, if y'all got these points that y'all want to go through 1 through 7, start at 1 and end at 7, and we'll do it like that. They didn't want to do it like that. They felt like they were getting boxed in. They felt like, that was kind of cramping their style and their flow. They wanted to be able to put on these presentations. They had slideshows that they wanted to put on. They had all of this stuff that they wanted to present and show. And they kind of wanted it to be like this grandiose presentation. And the judge kind of shut it down and felt like it wasn't necessary. He just wanted them to argue what they had a problem with and get on with it. He don't got time for the theatrics. He don't got time for the extras. He don't got time for the witnesses. He don't got time for none of that. Just tell us what you felt like you had was a problem, and we're going to get on with it. That's kind of the attitude that I kind of got from it. And so when I was sitting there, you immediately seen the mood of everybody just change, because I was just like, ooh, he is like really giving it up like that, because the judge, before like all of that stuff was posted, like he kind of was like working with them, and he wasn't really like, he was like allowing them to do their continuances, and they was continuing it here and continuing it there, and he was like, not really short with them. But in court, he was like, no, we're doing it this way. You put in your moving papers 1 through 7. We're going to start at 1 and we're going to end at 7. And the only thing that I'm going to tie in together is 3 and 7, because those match. But everything else, we're going to go 1, 2, 4, 5, 6. And then we're going to do 3 and 7 together because those match. But other than that, I'm not about to play with y'all. We're doing it like this. So then they continue to argue like, no, we got witnesses. They flew out of town. We got them in here from out of town. We want to put them on the stand so that they can testify and we can get them out the way. And then the judge was like, listen, you sent in a declaration of what they were going to say. I know what they're going to say. I'm going to offer it as proof, and I'm going to offer it as truth to what they, basically like, okay, that's what they say is the truth. Okay, cool. I accept it as that, and that is what it is. I don't need them to get on the stand. And Jose Baez was like, no, like they're going to expand on so much more, And then the judge was basically like, they should have said what they was going to say in the paperwork. And Jose Baez was arguing, and he was basically like, well, no, we only gave y'all a little bit of taste of what they gonna say, but we want them to really put it on thick on the witness stand. Like we only gave y'all a little taste. We didn't really let them lay it on thick because we want them to lay it on thick on the stand. And the judge was basically like, no, you should have laid it on thick in the paper. And they just kept going back and forth to the point where the judge kind of like gave them like this, and he was just like, we're starting. So are y'all going to start? Or if you're not going to start, I'm going to go to the next. I'm going to just keep skipping over until we get to 7. Like, that's kind of what he was giving it up. Like, we starting at 1. So, and then he started looking at, well, we going to start with Exhibit 40A. So what's your argument about that? And then they didn't want to argue about that. And they wanted to put on the witnesses. And it just was a whole back and forth thing that just got drug on until the person that they had as a third attorney, Christine, I think her name was Christine Belafonte, like they just kept going back and forth. She said, listen, Your Honor, because the judge was getting fed up. He like, I'm about to just skip over it if y'all not going to argue. We starting at number 1. I said we starting at number 1. That's where we starting at. So Christine, she said, listen, I'm going to just take over, okay? I'm going to just, So she took over and she started arguing her point. So the first thing that they wanted to talk about was the post on social media and the post on social media that Tory Lanez said that Kelsey was not the shooter. Okay. So on the Shade Room, there was this post that was in regards to the situation when, everybody was keeping up with the goings-ons that was going on. So this was a post that it says, producer alleges that authorities have matched the bullets from Tory Lanez's guns to the ones found in Meg Thee Stallion's feet. So somebody under that post said, people saying Kelsey shot her. To that, Tory Lanez's verified Instagram account replies and said, that's not true. Well, in court, they basically wanted to offer this in as hearsay and not as fact. Okay, so they wanted to argue that there is not proof that this was actually Tory Lanez making this post because it is hearsay, and they wanted to prove that it was somebody else. Well, the judge, from what I gathered from what he was kind of like trying to show, was that even if it wasn't him, it was somebody who he had authority he gave authority to his account, you know. And from what I understand, because, you know, information was coming in fast, but from what I understand, the judge said was, y'all are, okay, so let me back up. They said that they're alleging that this, number one, is not Tory Lanez who wrote this, right? This is what the defense is saying. Number two, they're saying that they had somebody who flew in that was willing to testify that they were the person who made the post and not Tory. The judge responds to that as he's seen who they said, because they didn't verbally say who the person was, but the judge looked at it from what I gather, from what it's appeared to me. He looked at it and he was basically saying that at the time of the original trial, the defense, McDezian, alleged that Tory Lanez had somebody who was his social media manager that was basically in charge of his account, and Tory Lanez was not the sole person in charge of his account. They listed a person, his account manager or media manager, or I forget like the specific title, but some type of page manager or whatever was in charge. Now, as we fast forward to court now, they're talking about some witness that's saying that it was them. According to what it appears the judge was saying, was that the person that they claimed at the original trial was the person in charge of the page, and the person that they're saying now was the witness is two different people. So the way that Jose Baez tried to basically explain that away was basically saying that McDezian had came on to the trial 2 weeks before the trial. He didn't have enough time to fully vet the information, and he was basically playing catch up to the information, right? The judge position on that was basically like, well, Tory Lanez is his account, so he knows who's in charge of his account. Like, why does it take confusion when it's Tory's account? He knows who's in charge of his account. So their argument back was basically like, well, it took us 2 weeks just to find the person who was in charge of this. And, you know, there's no way getting, ready for a new trial that McDezian would be able to, get all his ducks in a row as far as like the right person of who made the post or whatever, because it took us a dedicated sole 2 weeks just to focus on just who made the post. And then the judge kind of, to me, was kind of like, why? What's all the confusion? Tory know who operate his account. Like, that's kind of what I gathered from kind of what the judge was trying to say. And he was just not having it. He wasn't here for this being an argument. They felt like it was insufficient foundation to produce it. They felt like producing it was a discovery violation. They felt like it fell under a hearsay defense. And the judge also felt like that was bogus because he said, even if y'all feel that way, when this was presented at trial, there was no objection to it. Okay, so that was kind of what the judge was saying. He was saying that, well, if that's the case, well, why didn't they object to it in court? Okay, so the next thing that they had an issue with was Meg Thee Stallion's comments that she made during her testimony. Now, from what I recall, when I wasn't in court when Meg Thee Stallion testified, but when I look back at what, was said and what they're saying was said, and in addition, Megan made the statement of, I guess, something to the effect of Tory Lanez requesting for them not to speak on this situation because he was on probation and that he would get in trouble, and he didn't want to get in trouble because of, probation and things like that. Well, their argument was, well, Tory Lanez wasn't on probation, so they felt like this should not have been able to be stated as a fact of what he supposedly said because he was not on probation at the time. And they were saying that they didn't like the fact that the prosecution was telling the jury that Tory Lanez was on probation. Well, when the prosecution was able to tell their side, they felt like regardless if he really was on probation or not, they were basically like, people lie and they use certain things as a guilt trip to silence victims. I'm just giving y'all the summary of like the gist. That's not his exact words, but that's kind of like what I gathered. So what Alexander Bott basically responded to that whole allegation of, well, Tory Lanez wasn't on probation at the time, so how could he say that, he was on probation, so please don't say something to get him in trouble. And so the prosecution's response to that was, people use stuff as a guilt trip all the time. Doesn't mean that it's true, but doesn't mean that they didn't use it as a guilt trip nonetheless to make somebody feel guilty into, reporting something happened to them because you feel guilty that, you're going to get the person in more trouble or whatever. This is just not his exact words, but the gist of it. And so they were saying basically like people use, those type of framings of, oh, I'm on probation or oh, this or oh, that to manipulate people into doing what they want them to do. So whether he was on probation or not probation, they felt overall that was not even a big deal because at the end of the day, the judge made a stipulation to the jury that he was not on probation. He added it into his jury instructions and he put like a special, announcement that they had to be advised that Tory Lanez absolutely was not on probation. He had like this diversion type of thing that was well over before 2020 when this initially happened. And the judge was like, we let the jury know that he wasn't on probation. We did not leave them thinking that he was on probation. At the end of the day, he could have been using it as a guilt trip. That's what her testimony was. That's the victim's testimony of what happened. And it is what it is. And no, I'm not going for what y'all talking about. So he kind of like, booped that up out of there. And he felt like that was not an error. So they had number 3, and I think number 3 had something to do with Sean Hawley, and number 7 kind of connected. So then he skipped to number 4. Number 4 had to do with the DNA evidence of the gun. Okay, so if you guys know that there was, from both experts, reportings that the DNA was inconclusive and that it did not exclude or include Tory. There was like multiple profiles. It kind of was like smudgy or whatever, and they did not have enough accurately to include or exclude him, right? So Tory hired his own expert that was present at the original trial. The prosecution had their own expert. Both experts, Tory's expert and the prosecution's expert, they both agreed that the profile on the gun was inconclusive and it could not include or exclude Tory. So what happened was Jose Baez, he went out and got a DNA expert that I guess had worked with him before on the Casey Anthony trial. And from the research that I did, his name is Richard Eichenblum or something like that. As it pertains to Eichenblum, it came out that there was allegations that from the prosecution basically stated once they was like, well, we got this new DNA expert, and our DNA expert, Eichenblum, he's saying that there's no way that Tory Lanez DNA could be on the gun at all, none whatsoever. It couldn't be on it. He is excluded. So the judge kind of responds to that, or the response to like the DNA situation, because this went on for 2 days, so I'm trying to compact and summarize. The judge's kind of response to that was the DNA aspect of it kind of was like a small piece to a bigger puzzle, okay? And there was other pieces to the puzzle as it pertains to, you know, the GSR that was found on his hand. So although the question of, you know, was the DNA conclusive or inconclusive, he did test positive for GSR. So did Kelsey. So the judge kind of was like, the DNA being conclusive, not conclusive, whatever y'all trying to say, that's a small piece to a bigger puzzle. The bigger puzzle is all of the other factors that have been laid out that kind of go and as to his guilt, you know, and they're like, that's like a small piece of it. But even if we're to say that, why did his own expert say that it was inconclusive? And now you guys are saying something different when his expert that he brung to court agreed. So that kind of was that. They felt like, you know, well, we got this new expert, you know, he's here to tell us that he was absolutely excluded. And the judge basically was like, you guys can't cherry pick certain things and pick out like, okay, you know what I'm saying? You have to consider the whole picture. Like that is not the whole picture. There's so much more to it than just that aspect of the DNA. You know, like there's so many other factors here. So they argued and they said that the judge argued that number one, Tory had his own expert, and his expert stated that it was inconclusive at trial. Number two, when they were at trial, his defense attorney did not object. They called their own expert who agreed with the people's expert. There was no request to retest the items. And they alleged that the prosecutors withheld the lab notes and didn't give up the lab notes in a timely manner. And they felt like, you know, there was some manipulation with the lab notes. The judge felt like there was no evidence that the prosecutors withheld the lab notes. He said the DNA is a small piece of a larger puzzle. You can't say he didn't handle the item, and you can't say he did handle it. Okay? And so that was that situation on that. So then they went to the issue of his tattoo. Okay? And again, I'm trying to compact 2 days into just summarizing, you know. Hopefully this is a better follow through. So next, the next thing that they had a problem with was what is considered artist's creative expression. So if you guys don't know, there was recently a law or a bill or whatever that was passed through legislative that basically limited the admissibility of creative expressions. So it is Section 352.2. And also, it's 352.2, which is also the California Assembly Bill 2799. So 352.2 and AB 2799 is kind of falls under the same scope of, or AB 2799 was kind of before, and then 352.2 kind of went into effect today. Whatever. I mean, January 1st. Whatever. So anyways, so part of their issue, Jose Baez, Baroma, and the defense team, was they felt like there was several things that should not have been shown, and things that they felt like automatically prove guilt for Tory. Okay? So they felt like the appearance of him at the jail with his tattoos and his do-rag, they felt like that automatically caused prejudice to him and the appearance of somebody being guilty. They felt like him being attached to his rapper name, Tory Lanez, they felt like that automatically gave the jury prejudice into believing that because he's a rapper, because he has these tattoos, because he's wearing this do-rag, they felt like that image already prejudiced him from the jury, and they felt like that should not have been shown. Now, the picture in question is this picture right here that was shown. Where did the picture go? Okay, right here. This picture right here that was shown to the jury. Now, in this picture right here, this is the intake picture of Tory Lanez when he got booked into jail and when he got tested for GSR along with Kelsey and along with Quan. Now, in the intake pictures, let me show y'all. Hold on one second. So in the intake pictures, they also took in, like I said, Kelsey, and they had Quan. But I had the folder up and ready to go. Where did it go? Give me 1 second. I'm not redoing this video at all, child. Where is it? Hold on, we're gonna do this like this. There we go. Should pop up. Boom. All right, cool. We in business. Okay. Hopefully y'all riding with me. Okay, and y'all got it. All right. So this picture was shown to the jury along with the picture of Kelsey, which showed, the blood on her legs. It also showed, that, she kind of had like bruises and stuff. This picture was shown. There was also the picture of Quan that was also shown. Okay? So this picture of Quan, Tory, and Kelsey was all shown to show who got booked into court and who got tested for GSR. Okay, so they tested Kelsey for GSR, they tested Tory for GSR, and they also tested Quan, which was the driver for GSR as well. The defense felt like this picture gave prejudice to Tory because not only did it show him with these tattoos and his do-rag, it also showed him with this gun tattoo on his chest that they felt like was prejudice against him and showed his likeness for guns. Now, they felt like this particular photo of Tory Lanez should have been excluded. They did not mention Kelsey's photo. They did not mention Quan's photo, but they had problem with Tory Lanez photo being mentioned or shown as it pertains to his image and looking like, I guess, this thug rapper with the do-rag and the tattoos or whatever and showing the gun, they felt like it should not have went in. The judge response to that was that this was an intake photo. This was showing who got tested for GSR, and this is how they got booked in to to jail. And so the judge felt like the photo was relevant, and he did not feel like it prejudiced him because it was showing clearly who got swabbed for GSR, and it was them three that got swabbed, and him and Kelsey was the ones that had the GSR on them. Okay? So the judge felt like the only time his tattoo came up was when the officer was asked what his relationship with guns was like, and if he had, a likeness to guns and things like that. They felt like because this new creative expression limit was passed and it went into effect January 1st, 2023, they felt like this would have been excluded. They felt like this fell under creative expression, his rapper image, him with the tattoos, this whole image and look and likeness. They felt like it fell under creative expression and that it would have been or should have been excluded. The judge basically told them in a nutshell, you need to read it again because that's not what it means. Y'all have a misunderstanding of what got actually passed, and y'all need to read and confer and come back again because y'all don't know what the heck y'all talking about. So although California Evidentiary Code 352.2 does limit the admissibility of certain creative expressions, it does not include the creative expressions that directly relate to what can be a crime. So the issue at hand was Meg Thee Stallion did a testimony, and in her testimony, she basically stated that Tory Lanez was on probation, and why did I bring that up? Anyways, I don't know why I brought that up. Child, it's late. I'm getting sleepy, but I'm dedicated to get this thoroughly to y'all. So anyways, they said that 352 blah 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 whatever. They also felt like his stage name Tory Lanez, they felt like that also fell under that's why I brung up Meg Thee Stallion. I'm not editing this. It is what it is. I done got this far and I feel like I have a flow. I'm not editing this. It is what it is, child. Going back. Okay. So Meg Thee Stallion, she got on the stand, and when she got on the stand, she testified that she felt some type of way that Tory Lanez basically made a video making a mockery of the situation. So as you know, she's considered to be a stallion. A stallion is a stacked like a horse, like a built horse. Stallions, horses, is basically her whole likeness and her persona and things like that. She feels like, and she testified that Tory Lanez was basically taunting her in a music video, and that in the music video, he was butchering a horse's foot or leg or whatever. So because she had got shot in the foot and he's butchering the horse's leg, there was a dispute whether it was a cow, whether it was a horse. She testified that it was a horse and that he was butchering the leg. And she felt like it was her kind of like being taunted in a way of, of sorts. The judge basically told them that because they felt like his imagery, his music videos, All of that stuff is of creative expression. So the judge basically told them, like, yes, there is a limit to creative expression. However, that does not apply when it is made around the time of an incident, close in proximity to an incident, and when it resembles what's going on. He was basically like, it's too many link ups and correlations that resemble that this clearly looks like he's taunting her for us to ignore it. So even if 352.2 was in effect at the time he went to trial, this still would have been able to be her testimony because it was relevant to what was going on as it pertains to her feeling like she was getting, taunted to. The judge was like, the video wasn't even shown. Like, they didn't even show the actual video to the jury. She just talked about it, and they felt like it still fell within the scope. So I'm going to read California Evidentiary Code 352.2, and you guys let me know what you think, because what it sounds like when you read it, it sounds like what the judge is saying is truth, that if it kind of fits like you're, like one of those things, like if it kind of fits like you kind of bragging about harming somebody and it kind of matches kind of what happened to the person, it's like, we could use it. But they kept trying to argue that there was like this other case, and in this other case, the people basically had a music video. It's a totally different case, and what they tried to argue was there was this, I guess, alleged gang member, and they were trying to tie him to a crime. They used a music video that he appeared in to kind of, I guess, solidify that he had said XYZ or whatever. He had affiliation with XYZ. That case didn't really have, like, that music video did not really have any relevance to the actual crime. So they felt like the creative expression of him being in the music video was not admissible because it did not correlate directly with the actual other situation. So that was what it was, and that was kind of what was being fought about. The judge felt like that's tomato. This correlated to what seemingly was taunting in regard to this, and it was timely to when it had just happened and things like that. So I'm gonna pull up the creative expression definition. I'm gonna read it to you guys, and then you guys let me know what you think. So right here, let me pull it up. So it says, in any criminal proceeding where a party seeks to admit as evidence a form of creative expression, the court, while balancing the probative value of that evidence against the substantial danger of undue prejudice under Section 352, shall consider, in addition to the factors listed in Section 352, that 1. The probative value of such expression for its literal truth or as a truthful narrative is minimal unless that expression is created near in time to the charged crime or crimes, bears a sufficient level of similarity to the charged crime or crimes, or includes factual details not otherwise publicly available, and 2. Undue prejudice includes but is not limited to the possibility that the trier of fact will, in violation of Section 1101, treat the expression as evidence of the defendant's propensity for violence or general criminal disposition, as well as the possibility that the evidence will explicitly or implicitly inject racial bias into the proceedings. So in number 1, it kind of states basically what the judge was talking about, where he was basically saying that even though this 352 evidentiary code came into effect, he feels like the resemblance of the horse imagery and the timeliness of when it came out, he felt like it was fitting as true to the narrative that was being laid out. He also felt like the testimony that Meg Thee Stallion gave lended to her credibility. And he felt like even if this was in effect per the law, I still was able to allow Meg Thee Stallion's statement that he used the cutting of the whatever. Y'all get my gist. Okay. So then they were talking about how they had an issue with Tory Lanez being called Tory Lanez at trial. They were mad that he was called Tory Lanez. They felt like he should have been gone by Daystar Peterson. They felt like them presenting him as a rapper was automatically prejudiced. They felt like, you know, he shouldn't have been called by his name. He should have been given the opportunity to just present himself as a regular person. The judge's argument to that was, no, he's a superstar. Many people know him as Tory Lanez. Many of the witnesses don't refer to him or even know him as Daystar Peterson. And in order for us to give him a fair trial, we have to weed out the jurors who know him as Tory Lanez. We can't give him a trial and present him as Daystar Peterson when this is a public case. He's known to the masses as Tory Lanez. So we have to figure out if there are jury people who know him, who will have biases and who will, sway one way or another in an unfair manner based on him being a rapper. We have to use that to weed out and get a fair, balanced jury. He said, in addition to that, most of the witnesses only knew him as Tory Lanez. In addition to that, he said not only did the witnesses know him as Tory Lanez, he said the defense, McDesian, also knew him, or not knew him, but responded to him and called him Tory Lanez. So he's like, you can't go in here and tell us that we can't or we should not have called him Tory Lanez when the attorney that was representing him, he was calling him Tory Lanez. So like, what's up with that? So after the judge basically kept calling him out on like them trying to say, them trying to basically say like, what was they trying to say, child? I'm getting a brain fart, child, because, his name. They was like, you can't tell us that we was wrong for calling him that name when the defense was calling him that name. So then they started to be like, after so many times of the judge calling them out about them trying to use the original attorney as like the scapegoat of like not being prepared or doing certain things, they tried to use it as the guise of like, well, he was ineffective. Like he wasn't really like a good attorney. Like, cause the judge was basically like, was he effective or was he not effective? Like, are y'all saying that he wasn't ish? Or was he? Like, which one is it? Because y'all, and they started to say like, well, we didn't want to call him out. Like, we didn't want to badmouth him. But at the end of the day, we submitted, supplemental arguments. And he's, he did a bad job. And, we want you to redo the job because he did a poor job. And that was the whole thing in itself. So anyways, another issue that they had was Tory Lanez's right to testify without being impeached by his lyrics. So at the time of trial, and let me try to eat some ice real quick because I could feel myself losing energy again. Y'all who was on my original live, child, I ain't went to sleep. I said I'm just going to go for it. Let me eat some ice, child, because I feel myself falling back. Wake myself up. Ooh, that's cold. I'm sorry, y'all. I'm not editing this. I don't care. All right. Ice always help me wake up. Anyways, all right, so let's go. All right. So another problem that they had was Tory Lanez's right to testify. So as you guys know, at trial, Tory Lanez did not testify. And a part of the reason why he didn't testify, because he was considering testifying, was the fact that the prosecution basically told him what they might bring up if he hit the stand. So they were basically telling him like, oh, we might bring up this lyrics in your music, or we might bring up the time that you slapped Prince from Love and Hip Hop. We might bring up the time that you did the Diddy Bop with this person, and we might bring up the time that you didn't cross your shoe this time, and we might bring up the time that you jaywalked across. I'm exaggerating, but you know, they basically like laid out a laundry list of things that if he hit the stand, they possibly could hit him with. Now, in the defense's defense, they felt like it was wrong for them to tell Tory Lanez that they were going to approach him with certain lyrics and things like that, because they felt like it fell under the 352.2 creative expression. They felt like, you know, the lyrics was not a part of like something that could be admissible. They had an expert that was going to explain creative expression. And the judge felt like, I don't give a damn about hearing from your witness in person. You let them submit their paper. You don't know what I would allow them to impeach him with, just because, and this is kind of like a summary of what I gathered from what the judge was saying. He basically was saying like, just because they said they might hit him with these things does not mean I was going to allow each of those things. You don't know what I would have allowed or what I would not have allowed, because he did not testify. So you can't not testify and then say, well, they might have asked me this when you didn't testify. Like, now, had he testified and then they impeached him with those things and they ambushed him and said, well, you said this in your rhyme and that in your rhyme, and had the judge allowed it, then you can make an argument. But you can't make the argument of shoulda, woulda, coulda if he never took the stand to know what the judge would have allowed, because the judge was basically like, even though they told him what they might, you know, bring up, and this is just a summary of basically the gist. He basically was like, I have the authority at the end of the day to allow stuff or don't allow it. And y'all don't know what I was going to allow or not allow. So you can't tell me what shoulda, coulda, woulda, because he didn't take the stand. So you can't tell me what coulda, coulda, woulda happened. Next. So he nexted that argument. He felt like that wasn't an error. So the next error that they felt like should not have been admitted on the record was Kelsey's 80-minute testimony to the prosecution prior to her coming to court. Now, prior to Kelsey coming to court, she had been dodging talking to the prosecution. Okay? They had been wanting to talk to her for 2 years. Okay? Word got out that Tory had GSR. Kelsey had GSR. Were you the shooter, Kelsey? Was Tory the shooter? Which way you want to go? And once there was chitter chatter that it could look like she did it, then, you know, from what it seemed like, she started to talk to them. And that's just what it seemed like. Okay? So, when she went in, she pegged Tory Lanez as the shooter. She laid out everything that happened. She wanted to get her details right. She wanted to make sure she had everything clear and concise. She wanted to make sure that, you know, everything was like, no, this happened. And then if she messed up, she's like, no, let me get it right. Let me, you know, Like, you know, she wanted to make sure everything was concise and laid out. The defense, which is McDesian, when he got on the stand, or when she, before McDesian, when she got to court, she flipped. So everything she told the prosecution as far as like, oh, this happened, boom, boom, boom. She had a clear memory. She knew exactly what was going on. She didn't stumble over anything. She didn't get no brain fog. 2 months before court, she had it down pat. This happened, that happened, this happened. Once she got to court, she suddenly got amnesia. She couldn't remember. She don't recall. She don't know. I don't know. And they're like, well, you just told us. Now you don't know? So they felt like something was up with that. So McDezian, he started leaning in on Kelsey and wondering if she was giving her statement under pressure. And was she pressured to give her statement? Because now, under different circumstances, she's kind of like changing. So because McDezian was asking her if she was pressured, the prosecution, they wanted to prove that they didn't pressure her and they didn't force her to say anything in any type of way. Well, Jose Baez or Matthew Berhoma, I don't know which one made the argument. They kind of said, well, listen, y'all sitting here saying that the reason why y'all let this 80 minutes go in is because McDezian opened the door and saying that Kelsey was pressured. They was like, y'all full of BS. Now, they didn't say those words, but that's kind of what they was kind of saying. They was like, y'all full of BS. Y'all misled the court to think that McDezian is the one to open up the door and saying, she was pressured. And he laid out this whole thing and he's like, Alexander Bott or Kathy Tar, the prosecution, whichever one, it's late. He said they opened the door for that first. They're the ones who started saying, was she pressured to give a statement? Was she pressured to talk? Was she pressured this and that? And now y'all over here talking about McDezian was the one. Like, y'all misleaded that whole thing and making it seem like y'all let it in because McDezian said that she was pressured and saying that was the alley-oop to allow it to be in. And that's not the case. They started first. So he read through the transcripts and he read through Alexander Bott or Kathy Todd, one of them, saying, did you feel pressure? This and that, this and that, this and that. So the judge's response to that was, now, I agree with you that maybe the whole 80 minutes didn't need to be played on the record. I don't feel like the 80 minutes, and this is just my version of what he said. I don't feel like the whole 80 minutes should have been played. I agree with you. However, there was no objection by McDezian, which was the attorney at the time. In addition to that, he said either way, whether he objected or didn't object, Kelsey, and this is my words for what he said, Kelsey was a flip-flopping witness. She said one thing, she flipped the next, and then when she got to court, she totally had amnesia. So the judge was basically like, either way, we were going to play a majority of what she said to prove and to show the jury both sides of how she done flip-flopped. He said, now I agree that all of it probably shouldn't have been in, but most of it was going to get played and was going to be in, but there was no objection. So I believe it was Jose Baez. He basically was like, oh, in so many words, like, Judge, you lying. That ain't true because McDezian did object. Okay. He was like, there was an objection and he did object. So he went to this transcripts. And when he went to the transcripts, he was basically reading off, word for word where McDezian did object. So then once he said that, the judge was like, he objected, but he said that he was going to look into it further to give further objections. So I guess McDezian needed the full transcripts to make his objections. Jose Baez is saying that he never got the transcripts, and the judge is saying that once he was waiting for whatever he was waiting for, he never got back to the judge to fully make his ruling. So the judge said, when he said he was going to get back to him, that kind of left the objection open, and he didn't fully rule on it because he didn't fully close it out by being specific to what he was objecting to. Jose Baez's side of it was, well, he did object to it, and there really wasn't nothing else to add. And the judge was like, well, he did say that he was going to add something, and he didn't come back to me. But neither here nor there, I still was going to allow most of it in anyway. He said, now, was all of it necessary? Probably not. I agree. But most of it was going to get in anyway. So I don't feel like there was an error because I didn't fully rule on the objection. He didn't get back to me on the objection, and I'm not going to do his job for him. In so many words is what the judge was saying. Like, I'm not going to do his job for him, you know? And so, you know, that was that. So he said he didn't find an error in that. So let's see. So then we get to Sean Hawley and the allegations that was made as it pertains to her and her representation as it pertains to this trial. Now, Sean Hawley was representing Tory Lanez since 2020, and she had been his attorney throughout until 2 weeks right before trial. Jose Baez was alleging that she didn't really do her job that well because for the full 2 years that she was his lawyer, she didn't file any additional motions on his behalf advocating for him. She filed things like in response to certain stuff, but she didn't really like advocate, like, I guess, strategy or motions or whatever. They felt like she didn't do extra that she should have been doing. That was number one. Number two, once we get closer to the trial, there starts to be leaks. Okay. I believe there was leaks to DJ Academics and the way of basically there was some stuff leaked to the media that only the parties involved would be privy to. Okay. So that went against kind of her credibility, the Sean Hawley. Ouch. That was one. So there was leaks to the media and there was allegations that she was leaking stuff to the media, and they felt like she was, you know, feeling some type of way about, you know, that being a hindrance of her credibility. Alexander Bott was like, we didn't think that she leaked stuff to the media. We thought that Tory Lanez was the one leaking stuff to the media, and that's what that allegation was. We thought it was Tory Lanez that was doing it, but we didn't have no proof. So no, that wasn't an allegation towards her. We had an allegation towards Tory, but we didn't have proof. So that was that. So then there was an allegation that she helped set up the bribe for bribing Kelsey. So according to Kelsey, she kind of made a statement of saying that Tory Lanez told her under the advisement of his attorney that he had to basically offer the bribe in a way of like, oh, I want to be able to like invest into like something that you got going on. Like, you know, kind of like I want to pay you off to shut up, but I got to do it in a way of like buying you a business or investing into you so it don't look like I'm paying you hush money. That's just kind of like the summary of what the allegation was. So it was alleged that Tory Lanez told Kelsey that the lawyer told him to ask for the bribe in that kind of way. And so that was kind of an allegation against her, kind of like misconduct. So there was that, there was the leak, that kind of, you know, stuff that was leaked to the media that was clear came from somebody that was that shouldn't have had stuff coming out. And so Tory Lanez felt like she was acting in her own best interest and leaving him high and dry when the heat got on in the kitchen. So I'm going to read an excerpt from Megan Cunith's Substack that kind of explains this. She has a Substack, and she kind of like detailed their issue with Holly, and it'll make it easier for you guys to understand. I know, child, y'all be having a thing for Miss Megan, child, but child, that got nothing to do with me. And I'm gonna read this because it's gonna give you the best summary other than my gibberish. So it says, Judge Hereford delayed the trial at Holly's request last September because Holly said she was busy representing now former Los Angeles Dodgers pitcher Trevor Bauer in his arbitration with Major League Baseball over his suspension. The arbitration was going on when Lane's trial began in December, and media reports cited that as a conflict that led Holly to give the case to Mendesian. However, so basically she said, listen, I got this case going on with this baseball player. I can't go forward with representing Tory. Tory Lanez motion indicates it's actually the bribery allegation that drove Holly from the case and put her in a position to choose between her interests in loyalty to herself and her professional reputation, then her loyalty to her client. So basically, as you see here, there was allegations of leaks to the media, and the lawyer Tory is leaking stuff to the media. Then there's allegations that she's helping him set up a bribe and, things like that. And so those things are kind of going on her, credibility. So Tory Lanez felt like right up until trial, suddenly you have this arbitration that you can't help me out. That's leaving me to find a new attorney. So their argument basically was Sean Holly acted in her own best interest and left Tory Lanez high and dry with Mendesian. Mendesian comes on 2 weeks before trial, and he's not fully up to speed. They wanted to argue that he was like incompetent to go forward. They wanted to argue that he was playing catch up, that he was ambushed with things that he wasn't prepared for and he wasn't ready for. And the judge's response basically to that was, I offered to give him time. I offered to make this a long, what was the term? A long cause. He offered to send this to a long cause court, and that would kind of continue things. Matter of fact, let me get the actual definition of long cause court, because he said he offered it to go to a long cause court. So a long cause hearing is defined as a hearing on a request for order that extends more than a single court date. A trial brief or hearing brief is a written summary or statement submitted by a party that explains to a judge the party's position on particular issues. Let's see. What is the order? Okay. Hold on. Let me get a better definition. So anyways, he said he agreed that it could be a long. I'm trying to see more definitions of it. Anyways, he said that so basically they was like, listen, Mendesian wasn't ready. He wasn't prepared. He was rushed into this. He wasn't able to, adequately blah, 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 blah. The judge said, listen, I offered and recommended this to go to long cause court. And I think the recommendation was like 90 days, or it would handle, like it would do some type of delay. He threw out the number 90 days, but I forget exactly what the 90 days was, if it was going to be delayed 90 days or like that it would take 90 days for them to fully lay out the trial. It was something about 90 days, child. But anyways, long story short, the judge was like, I offered these Negroes time to continue and get him prepared to have a longer time. He denied that. He said he was ready. The prosecution also said they was ready. I offered both of them like, hey, y'all want to delay this? Y'all sure? You know, whatever. And they were like, nah, we good. We ready to go. So the judge was basically like, you can't, me, the judge, offer you time to get prepared, and then you come back saying that you wasn't prepared. That's not how it worked. That's not gonna fly. That's not my problem. It is what it is. You can't tell me that you ready, and then when you don't like the result, come back complaining saying that, well, I wasn't ready, I wasn't equipped, when I gave you the opportunity to extend it. So the judge was like, get out of here with that. I gave you the opportunity, you didn't do it. So they were like, well, judge, he was ineffective. He wasn't, well, we're going to say he's ineffective. And then the judge was like, well, why in your original papers, you didn't say he was ineffective counsel? Why are you now trying to argue that he's ineffective counsel all of a sudden? And they were like, well, we didn't want to bash another attorney. We didn't want to throw another attorney under the bus. We got like respect for him, but at the end of the day, like he really wasn't, a good attorney. He didn't object to stuff that he should have, blah, blah, blah. And the judge was like, y'all added that under seal and under supplement, but child, boy, bye. Like he was ready. He seemed prepared to me. He seemed adequate to me. He seemed like a good attorney. I seen him do his thing and he did what he needed to be done. And the judge at the end of it, he was just like, if everything went y'all way, the same result would still happen. The same result would still happen. At the end of the day, he reverted them back to, all of the issues that was stacked against him, other than the stuff that they were trying to cherry pick here. The judge basically said, listen, even if you had your way on some of these things that you claim that you would not have had your way on, you still would have had the same outcome, because at the end of the day, all signs lead to him being the person in charge. We got the jail call, we got the text, we got the Kelsey, we got the Sean Kelly, we got the this, we got the that, da, 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 and it's a wrap. So the judge finally was like, listen, motion denied. So after the judge basically denied it, the family kind of like, you heard them kind of like all throughout it, like huffing and puffing or whatever. Before he denied it, Tory Lanez, the first day when the judge was like kind of shutting down everything and not really effing with them, Tory Lanez, as he was about to walk to his chambers, he was basically like, judge, like, please don't ruin my life. Don't ruin my life, judge. Like, all while he was in court, Tory Lanez was sitting and he was kind of like zoning out. And he was like, I would be sitting sometime, I'm like, is he looking at me? But he would just be like zoning out, and he would like, and his head would be like, and he kind of was out of it. And it was one time when the judge was like talking to him as it pertains to whether or not he was going to waive his attorney-client privilege in the supplemental documents that they submitted. And the judge was like, do you understand? Because I don't think that you would want your attorney-client privilege to be waived. Like, it's some things in there that I don't think that you want the public to see, that you communicated and you said with your attorney and things like that. And so the judge was like, are you sure you want to waive your attorney-client privilege and show the communications? And so the judge was talking to him, and Tory Lanez was like, say that again. And then the judge was like, talk to your attorney. Like, talk to your attorney. Let your attorney explain to it. So then Jose Baez explained it to him. And then Tory was like, yes, I understand. I agreed to have my attorney-client privilege waived for for the specific supplemental document. He didn't agree to all communications with his attorney be waived. He agreed to what they submitted in their supplemental papers. He agreed to that information being out in the public. But it was like he was just sitting there like out of it. Like, I think once he realized that it probably wasn't going to go the way that they anticipated, he kind of was out of it. His family, obviously, they were kind of like agitated. They were like, you doing a lot of kind of like, you know, like kind of like, damn, like, you know, kind of like frustration, but there wasn't any type of commotion or any crazy outburst or anything like that. It just kind of was like, you know, cool. The wife, you know, before she had kind of had some things, you know, but she was like very friendly to me. She gave me a hug and we talked, and I was just telling her like, you know, I don't have nothing against y'all. I'm just, you know, doing my job. And she was just like, you know, I understand things like that. It's nothing against you, whatever. And then, you know, she gave me a hug and like, you know, she was friendly throughout. So that was cool, because at first I was kind of like, one of these people gonna try me. And at the end, somebody ended up trying me, but it wasn't them. It wasn't the father. It wasn't the wife. They were friendly. They were cool. They, you know, it was what it was. I kept my distance from them. I let, you know, try not to impose, you know, because, you know, they have sensitivity that's going on. It was what it was, but it was another knucklehead and it child. Anyways, that was that. So after, everything got concluded, the attorneys walked out and basically spoke to us, the media, about certain things. So all throughout this trial, all throughout, even back in December, anytime you would try to get any type of statement from Alexander Bott, which was the prosecutor, he would just be on some like high bye type of stuff. He did not really give any type of true like statements to the media. He kind of was like, oh, I think the judge did a good job, or oh, like I think he was fair. Like it was very brief, very short, very quick. He'll like wave and keep pushing. So today, after the trial was denied, the retrial request was denied, the lawyers was a little bit more, you know, talkative or whatever, including the prosecutor, Alexander Bott. So this was our time to be able to ask him questions that pertain to the case, questions that pertain to Tory Lanez. And we're here for Tory. We're here for the case. We're not here for other people. We're here for the case. That was our chance to ask that. Other people made it about other stuff. I wanted to ask the relevant questions. And so I'm going to show you guys that exchange. Basically, what he said was Tory Lanez was facing a minimum of 9 years. And it can go up from that because there was enhancement charges on top of that. So I'm going to share with you guys some of the videos that happened in court. And then I feel like we're going to be out. So the very first day, because there was 2 days that this went on. The very first day, this is what I got from
It's always the fucking thing, yeah. Okay, here we go.
How do you feel it went today? No comment?
I have nothing to say. We're gonna keep fighting. This is just the beginning.
Have you looked at the medical reports? That one doctor.
Do you feel like the judge was fair today?
One of the doctors took out glass, and the other said he took
excuse me,
out
can I get by you?
molten, connected to the knife blade.
Do you feel like the judge was fair today?
Did you get that? Did you get that?
About all these things that we've reviewed this record thoroughly. So we have to pick which issues we're going to address with the court based on what we think it has the best likelihood of success. And that's where we're moving forward. All I can say, guys, right now is this is just the beginning. And we plan on putting forward as strong a case as possible. And we're not going to stop till we get them out.
Do you feel like everything was fair today?
Do you feel like the judge was fair? They said that he was being a little bit dismissive to you.
get irate.
I'm not gonna comment on what people are saying. So let's get going.
Was Tory Lanez told to shut up in the court today?
Okay. So as you see, this was day one when the judge he had not made his official ruling yet of his denial, but you can kind of tell which way he was going to go by how he was treating them in court. I believe this is also day one. So how are you guys feeling after the ruling?
Oh wait, no, this isn't day one.
Denied?
We think Judge Hereford made the right call today.
That's today. My bad. That was today when Alexander Bott first came out at 12 p.m. So when he first came out at 12, the judge had just denied it, right? So he had just denied it, but there was still things that they wanted to put on the record. So it wasn't officially done. You know, it wasn't officially like all the way over because Jose Baez still wanted to argue some stuff. So this is Bot kind of being short with, you know, information. So how are you guys feeling after the ruling? Were you expecting it to be denied? This was today.
We think Judge Hereford made the right call today. Yeah.
Oh, okay. All right. Thank you.
Thank you.
Okay, so as you can see, he was like very quick, and that's how he had been the whole trial, like not really that talkative or anything. So once we went after the lunch hour and Jose Baez added some things to the record, then we went back to talk again. And once we went back to talk to see if anybody was going to make statements, this is what happened. So I'm going to play, I edited the version that I posted earlier, but I'm going to play you guys the full exchange now.
The judge reviewed the moving papers, he looked at the declarations, and he came to the right decision. But like I said, it brings me no joy to see somebody in Tory's situation throw his life away in a case like this. But you know, actions have consequences, and what we saw today was the legal process play out, and Judge Hereford got it right.
He can't
I can't answer that question.
What are you
I haven't. The 170.1 is a pretty rare procedural mechanism. So it seemed to me that the prejudice they felt came to light only after the judge started ruling against them. At least that's how it was perceived.
Oh, that was another thing I forgot to mention to y'all, child. I'm sorry. I've been talking for almost 2 hours now. I forgot to mention, before the judge made his ruling, Jose Baez, Matthew Berhoma felt like the judge kind of was dismissive towards them, not letting them do their thing. So he requested a 170.1, what is it? Let me see, 170.1 to disqualify the judge. So he requested a 170.1 disqualifier. So a judge shall be disqualified if any one or more of the following are true. The judge has personal knowledge of disputed evidentiary facts concerning the proceeding. A judge shall be deemed to have personal knowledge within the meaning of this paragraph if the judge or the spouse of the judge or a person within the third degree of relationship to either of them or the spouse of such person is the judge's knowledge likely to be material witness in the proceeding. The judge served as a lawyer in the proceeding or in any other proceeding involving the same issues. A judge shall be deemed to have served as a lawyer in the proceeding within 2 years. A judge who served as a lawyer for or the officer of the public agency that is a party to the proceeding shall be deemed to have served as a lawyer. The judge has financial interest in subject matter in a proceeding or whatever. The judge or spouse of the judge or a person within the third degree of a relationship to either of them or the spouse of such person is a party to the proceeding. a lawyer or spouse, and number 6, for any reason. The judge believes his or her recusal will further the interest of justice. The judge believes there is substantial doubt as to his or her capacity to be impartial. A person aware of the facts might reasonably entertain a doubt that the judge would be able to be impartial. Another one was by reason of permanent or temporary physical impairment, the judge is unable to properly perceive the evidence or is unable to properly conduct the proceeding. And so I think they kind of was like weighing on number 7. But so they were basically asking the judge to disqualify himself. So there was other things that it can fall under. But right before the judge made his ruling, they wanted to have him disqualify himself as a judge. The judge was like, get out of here. No, I'm denying that, and go somewhere. So that's what he's talking about here. The request for the judge to be disqualified. Sorry about that. I didn't mention that in the breakdown, but child, it was a lot.
By me.
What are you
I haven't. The 170.1 is a pretty rare procedural mechanism. So it seemed to me that the prejudice they felt came to light only after the judge started ruling against them. At least that's how it was perceived by me. But I believe the motion was deficient in a number of ways, and the judge struck it for those reasons.
It sounds like it's undecided if Megan's going to talk in person or citizen. Would you have any idea on what the decision is like on that?
We don't know yet. We'll talk to her people. She's going to give a statement in some form. We don't know. It may be in person. It may be recorded. It may be written. We'll see.
All right, so that was Megan Cunith basically asking about Meg Thee Stallion's impact statement. So when we were about to let out, Alexander Bott said that there would be a victim impact statement that they wanted to consider for the sentencing. Megan Cunith was basically asking, in what capacity would that victim statement be made? Would she come to court? Would it be written? Would it be video? How would it be? And then that was Alexander Bott saying that he would get back. How much time are you guys looking to request?
We'll talk to her people. She's going to give a statement in some form. We don't know. It may be in person. It may be recorded. It may be written. We'll see.
How much time are you guys looking to request?
That'll be in our sentencing memorandum, which we'll file in the next 2 weeks. The sentencing range on this case is roughly 9 years all the way up to 22 years in 8 months.
So minimum is 9 years?
Yes, the minimum would be approximately 9 years. Now, the judge could theoretically stay certain allegations and get below that, but that would be pretty unlikely.
Wow. So he get 9 years. My job as a deputy district attorney is to enforce the laws as they're written by the legislature, so I don't really make those decisions. So I would say that anytime you point a gun at somebody and pull the trigger 5 times, that's an action that could easily kill a person. I think that's an action that deserves serious consequences.
But that's not necessarily what happened, because Sean Kelly said something totally different. He said the 2 women fought, and then they were outside, one went back into the car to retrieve something, and then there was flashes. So how do you put 5 shots in Tory's hand?
Well, that's based on Megan's testimony, Kelsey's testimony, and Sean's testimony together. So
yeah, but Sean Kelly's testimony changed after he spoke to you. In the transcripts, it says what I just said. He didn't add they were stomping on her and trying to kill her and throw her on the river until he got on the stand. He was originally thought of as Tory's witness, not Megan's. And the credibility of witnesses is wrong.
That's right. I would just add that Sean Kelly also said that he heard 5 shots, and the theory of the case from the outset was that Tory fired the gun 5 times at Megan. That was our theory of the case.
That was your theory,
and that's what was presented to the
right?
jury, and that's the jury ultimately endorsed that theory and voted guilty. I mean, to convict somebody of assault
with a semi-automatic firearm. That's what they believed was true, based on the facts that they heard. So
No, I
it's
agree.
not my
No, I
place
got
to
you.
question the judgment of the jury.
Missing from the conviction filings was anything about the jurors. A lot of the times in motions for new trial, you'll see defense attorneys quote jurors, things like that. Have you heard about whether anyone's had contact with them about the
No. One way you can get a motion for a new trial is if a juror says something inappropriate happened, like they flipped the coin and reached a verdict that way.
Yeah, but what about a
that wasn't the
reporter
case here.
that's the mouthpiece of the prosecution that lies blatantly that the defendant is screaming in public?
I think the reporters that cover this case are doing a great job. I think
You didn't answer the question. What about reporters that do things that are a lie and they're promoted by BET, which is owned by Viacom, which also has a relationship with Rock Nation? How is that fair journalism, or how are they our real court reporters?
I have nothing but respect for the media that cover this case. I think everybody's doing the best job they can.
That's slick.
Can you explain the enhancements? I know there's like a gun enhancement. Can you explain that? Like there's a 9-year minimum, but on. All right, so basically what was happening was instead of us being there for Tory and asking questions that were relevant to Tory, now when she was asking about Sean Kelly and stuff like that, then I feel like that was relevant. Like ask about the witness and if you felt like he flipped or whatever. But if we're here for Tory, who gives a damn what anybody else is reporting? Because that is not what that's not what determined him to be found guilty. What determined him to be found guilty was what evidence was presented in court, not what the reporter said, her interpretation of what happened. It was what was presented in court. So I feel like a lot of times like we get away from and even like just little petty beefs here and there. It just be like, let's all show up to do the job that we came for and stop worrying about what each other person is doing. If we dare to report for Tory, like let's ask the relevant questions as it pertains to Tory. Who gives a damn what, like, but anyways, so then that's when I did my follow-up question because I wanted to know about what they were requesting, what was the minimum and what he was looking at. And then on top of that, what can be stacked on as it pertains to the gun enhancement charge as well. So let me bring that back a little bit.
The media that cover this case, I think everybody's doing the best job they can.
That's slick.
Can you explain the enhancements? I know there's like a gun enhancement. Can you explain that? Like there's a 9-year minimum, but on top of that, would there be a gun enhancement stacked on that?
Yeah, so the assault with a semi-automatic firearm carries a sentencing range up to 9 years. But then the jury also found true that the defendant personally used a firearm, which carries a triad of 3, 4, or 10 years. So
but this is the other weird question.
Can he finish? Let him finish.
Let him finish.
So theoretically, on count 1, you could get to 19 years if you got high term on the assault with a semi-automatic
You
firearm.
don't want to be an asshole, but
and then high term
what are you
on the
talking
gun
about?
allegation. But that would be if you got
Child.
term on the assault with a semi-automatic
You
firearm.
don't want to be an asshole, but
and then high term
what are you
on
talking
the gun
about?
allegation. The defendant personally used a firearm.
Slick.
Can you explain the enhancements? I know there's like a gun enhancement. Can you explain that? Like there's a 9-year minimum, but on top of that, would there be a gun enhancement stacked on that?
Yeah, so the assault with a semi-automatic firearm carries a sentencing range up to 9 years. But then the jury also found true that the defendant personally used a firearm, which carries a triad of 3, 4, or 10 years. So
but this is the other weird question.
Can he finish?
Let him finish. Let him finish.
So theoretically, on count 1, you could get to 19 years if you got high term on the assault with a semi-automatic
You
firearm.
don't want to be an asshole, but
and then high term
what are you
on the
talking
gun
about?
allegation. But that would be if you got high term on both.
But how did you prove it was his gun, though?
So for that allegation, you don't have to prove that it was his gun, just that he...
Child, that annoyed the living daylights out of me, child. Because it's like, listen, I'm like, we all here to ask questions. You ain't the only one that can ask questions. We can all ask questions. We all are here to report. So it's like, you asked your question, he got done answering it. Another person's asking their question, let them finish. Let them get done with answering it, and then ask your question again like I did. I asked my question. I had a follow-up, but before I could get my follow-up out, you asked the question. I waited, asked my follow-up. Like, that, like, Neek, you in front of the DA, calm it down. Because immediately I'm just like, not you calling me an asshole and you the one. Child. Anyway, so let me play the 5 more seconds of what he said.
Personally discharge the firearm.
Yeah, but it's DNA. But the DNA.
Based on the
DNA.
yelling, this is the last question we're going to answer.
Yeah.
Can the enhancement?
Based on that, we're going to be leaving.
Can the enhancement?
Well, he's not a part of the
Can
meeting.
have this, okay?
Run consecutive.
Yeah, good question. There's discretion in the trial court to run concurrent or consecutive. Yeah. So there's discretion. Yeah.
Okay. Thank you, everyone.
Yeah, but was there anything that you wanted to add, being a person who testified and a witness to the case? Was there anything that
She's making it out.
what was that?
Thank you for asking the question.
Okay. Thank you.
Anyway, so young lawyer.
All right, so that was that. So after that, like, that was the first and only time that we were able to, like, I didn't even get to ask my will he be deported question. I didn't get to ask, like, my other questions, because as we were asking him questions, he's the prosecutor. He helped litigate to put him behind there. Like, what they trying to get him for? Are they trying to deport him? What gang enhancement are you trying to add? Like, I'm sitting here trying to, like, I want to ask the questions. Other people are trying to ask questions. And then some guy in the background, he just start going crazy in the background. And so the lady, the deputy was like, well, we got to get him out of here. Well, I'm shutting this down for his safety or whatever. And I just kind of got irritated, because it's like, this is like, we've been here every single day. This is the first time that he's actually forthcoming and trying to explain, you know, the ramifications of things. And I felt like the ramifications of what he was facing was important. Is it a minimum of 9 years? Are y'all looking to request in your memoranda the full thing? Are y'all looking to request the full enhancement charge on the gun? Like, is he gonna get deported? Like, I didn't get to ask that question, but the guy started going crazy. He started, like, coming at me saying that I'm disgusting because of my narrative, woo woo whoop, and all this stuff. And it just was a whole thing, child. I'm sure y'all saw a piece of it on Armand's channel. But it just was a lot. And I feel like if we hear, like, let people who come to do their job do their job. You know, like, coming up to me saying little stuff and doing, like, child, if people gonna come do their job, let them do their job. But, child, that was the whole thing. Then baby girl talking about calling people an asshole. Like, girl, you is, child. Anyways, so that was my breakdown on things. Was there any other videos that I wanted to share? Because I didn't, child got mad again, child. Ooh-wee. Was there any other videos? I think I pretty much covered everything. If I missed anything, hey, it is what it is. I tried to get everything out. His sentencing date is June 13th. They are going to consider the factors of aggravation, which is the gun enhancement. By May 23rd or 24th, they have to have their memorandum in, which is what they are requesting. And then by June 6th, the defense is gonna, like, respond to, like, whatever they're requesting. And then on the 13th is gonna be the actual sentencing date. In the meantime of the leading up to the 13th, Tory's team, Jose Baez and Matthew Bahoma, their whole objective is to, before he gets sentenced or before anything like that, they want to get this judge off of the case. They want him to get put it out of here. And I feel like, I don't know if that's a good idea to piss off the guy that's about to sentence your client and stuff like that. So the prosecution also got mad at, I don't know if I brung it up, but they got mad at the fact that, Tory Lanez and his attorneys was going on social media and, riling up the fans and talking about the DNA was excluded, this and that. And feeling like, the expert that they're trying to now say is an expert, they feeling like he's incompetent. They said that he has something in 2016 where he was discredited as a DNA expert and he admitted that he was self-taught. Then the expert, he came back and he said that he had accreditation and that he was accredited and, he got disqualified by a judge to be an expert. But since then, he was still trying cases. He said that, that was a nothing burger. He said that he actually was qualified and, that was that whole thing. So it was a whole lot going on. I tried to lay out the things in the best of my ability. Hopefully you guys were able to follow. But yeah, it was a whole lot of going on. I expect a whole lot of at the sentencing. But guess who's going to be prepared and ready for any and everything? I will. Okay. I'll see you guys on the next video. If you guys like this video, make sure to share it. And hopefully I'll give y'all more soon. For those of y'all who was on my original live, when I originally went live and I told y'all I was going to go to sleep, I ain't went to sleep. I just did this again. Okay. And it's a wrap. But I knew tomorrow I was not going to be able to get to it. It wasn't going to happen. I had to thug it out and collect my thoughts, collect myself, and get it going. So with that being said, that's all for this video. Hopefully I was able to lay out everything that went down in court. Hopefully I was able to give you guys more clarity as to what happened. And I will see you guys on the next video.